Oh yeah, this is an interesting one too. Yeah, Memonex says I'd employer claim I set a precedent by working certain patterns and become contractual through mutual de facto consent. Yeah, that can work as an argument. And that can work as an argument. Um, it is, yeah, that can work in contracts as well, generally speaking. So that is a possibility in contracts, generally speaking. Um, it can be behavior. Courts will frequently look to behavior on a contract as a way of interpreting the contract, especially if the behavior is within the language of the contract, but not necessarily required by the contract. So courts will look at this two ways. So first of all, is the behavior outside the bounds of the contract? In which case we're viewing it as a modification to the contract, right? Modification by behavior. So that's one possibility. The other possibility is that the behavior is within the bounds of the contract, but not exactly required by the contract. So yeah, contract by behavior. So, if just to pick an example off the top of my head, let's suppose that, I have a contract with you, and the contract requires you to deliver to me cement every day because that's the nature of my business. You're a company that provides cement. This is what you do. I'm a general contractor. I whatever. So we have a contract that says you must provide me cement every single day, but it doesn't actually specify a time in the contract, which seems like a massive oversight on my part, but whatever. But let's say that you deliver me concrete every day at 7 a.m. And I never said anything about it. You never said anything about it. We're just operating along happily. You deliver me concrete every day at 7 a.m. And then one day, and then maybe not even one day, maybe then, after some period of time where this is happening, then maybe you start delivering to me at 11. And I'm like, but we agreed on 7. It's like, that's not what the contract says. Right. So the behavior of the parties can often be a way of interpreting the contract where the behavior is consistent enough for long enough, and if it's not modifying the contract. So if it's modifying the contract, like you start delivering me only every other day at 7. So there's a difference between you providing me, cement every other day at 7 versus every day at 11, and sort of how the courts will look at it. So modification, and also you get into issues of waiver because the condition was waived. And a lot of this, of course, can be specified by the contract itself. So you'll often have these problems solved by the contract itself because the contract will say, for example, our acquiescence to something does not constitute a waiver on our part. So like just because we let you deliver at 11 a.m., if the contract says 7 and we said 11's fine, we say, oh, that's not a modification. The contract itself can specify that. So that was a little off topic, but yeah, that's possible. That's possible. Behavior on a contract that is long enough, consistent enough, can potentially be a modification on the contract, or at least, if not a modification on the contract, can be a way of understanding the contract. Also, you get into this idea of what is understood within the relevant market. So in terms of understanding a contract, so for example, let's suppose you're a cement company and I'm a general contractor, and let's suppose that I'm a little bit more specific of a general contractor. Let's suppose I'm a general contractor for residential buildings. Okay. And let's suppose further, because I'm making shit up. Let's suppose further that the cement that is for residential buildings is well known and understood in the market. And let's further assume that the residential cement is substantially different than what would be used in a commercial context. Now, maybe this is regulation, but maybe not. All right. So it doesn't really matter either way, although the regulation would actually help further. So you could assume there's a regulatory requirement, uh, concrete that's used in residential building must be X, and concrete that's used in a commercial building must be Y. So if there's a regulation in place, that would further help, but it isn't necessarily required. Let's just assume that there's not even a regulation. Let's just assume that for whatever reason, businesses, when they make concrete for residential buildings, always do X, and when it comes to commercial, always do Y. And why? Who knows? I don't care. They just do, right? But this is understood in the community. This is understood, right? If I'm making the cement for the residential buildings, it's X. If I make it for Y, if for commercial, it's Y. And everyone understands this. Everyone understands this. Is it a regulation? I don't know. Maybe, maybe not. But it's an understanding everyone has. Okay. And I am Uncivil. I am Uncivil Residential General Contractor Inc. Okay. That is what I do. I am a residential contractor. I build residential buildings. That's what I do. I'm really fucking good at it. Right. And I sign a contract with you, my cement supplier, and be like, I need cement. Now, me being a complete idiot, I didn't specify in the contract what kind of cement. I didn't specify for residential buildings because I'm a fucking moron. Okay. I didn't specify any of this because I could have cleared all this right up in the contract, but I didn't do that because I'm a fucking idiot. All right. All I wrote is, I want cement. Period. End of statement. Right. And you start supplying me cement that is commercial for commercial buildings instead of residential. And I'm like, that's not fair. I need the cement for the residential. It's like, oh, it doesn't say that, which it doesn't because I'm a fucking moron. Okay, well, fortunately, the court is going to come save my ass, okay, on this situation, because the court's going to be like, okay, well, this is what is understood by cement. The contract doesn't specify it, but in the ordinary courts of normal trade, in this particular context, what means is cement that is this. That is what everyone understood. We understand the term to mean this, and bingo bango, the court will come save my ass. So you can have that kind of scenario. And I remember a case that actually was kind of like this, right? There have been cases that are like this because people are fucking morons. I remember a case in law school we studied where it was chickens. And it was some sort of food related thing. And apparently, like, chickens for food, like to be eaten, have to be like a certain kind of chicken because some chickens are not suitable to be eaten. I'm not an expert in chickens. I just remember vaguely the case existed, right? So the contract called for chickens without any specificity because, again, we're a moron and we now have to figure this out in court, right? So it just said, deliver me chickens. And one day the supplier provided chickens that were not food grade chickens. Don't ask me any questions. I don't know any more than I'm telling you. I just know that they weren't suitable to be eaten. Okay? There is apparently a difference, and this difference is understood, and there are the chickens to be eaten and chickens not to be eaten by human beings. And like apparently this is understood in the trade, right? Good chickens for eating, not so much for the chickens for eating. Maybe dog food, but not so much for the human beings, okay? And the contract, all it called was for chickens without any specificity because he's a fucking moron. All right. And so then, one day the supplier turned up with the, non-food grade chicken. And like, that's not fair. And like the contract says, oh, it's just chickens. And it just says chickens. Any kind of chickens will do. And the court saving the guy's ass said, okay, look, the contract doesn't specify what kind of chicken. But look, this contract is clearly in contemplation of food stuff. This is a food manufacturer for the human beings. And what is understood in this domain is these kinds of chickens, not these kinds of chickens. So this term chickens means this, not this. And you have to supply this because that was an understood term and blah, 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 blah. So these kinds of things have actually happened. All these problems can be solved, by the way, if you just specify it in the contract like a normal person. But if you don't do that, then the courts have to get involved, and this is some of the bullshit we have to do. Because now we have to fix your shit. Also, while we're on the subject, as long as we're doing some legal education over here, why not? As long as we're on the subject, if a term has a private understanding between the parties that is mutually understood, that deviates from common understanding, the mutual understanding will also uh, differ. And I don't remember what case this is, but I remember it existed. So maybe it was chickens, maybe it was something else. I forget what it was. Like the contract called for, I don't know. I don't remember what it was. Let's say the contract called for delivery of 100 units of two by fours. Okay. The contract says you will deliver to me 100 two by fours. Okay. That's what the contract actually says. All right. But we, as a matter of our private understanding, okay, we say that, you know, what we mean by two by fours, what we really mean is chickens. I don't know why we do it. Don't ask questions. Okay. I'm just telling you. All right. So the contract says 100 two by fours, but we mutually understand the term two by fours to mean chickens. Okay. So you actually show up with actually 100 two by fours. And I'm like, that's not fair. What I wanted is chickens. And you said, but the contract says two by fours. If you can prove, and again, this is all a problem, but if you can prove the term two by four really meant chicken, the court will enforce the mutual understanding over the word. Because what does the word mean? What does two by four mean? Right? And now what it means is chicken. Why did you call it a two by four and not chicken? I don't remember. But this case has also happened as well. Not that exact example, but the same idea. Right? The contract calls for delivery of something. But what it really meant was something completely unrelated to that. I don't remember if it was an illegal thing. I don't remember what the issue is. I don't remember why they did it, but they did it, right? They wrote into the contract something completely different from their mutual understanding. But, you know, when it came to trial, we finally found out that, yes, you really did have a mutual understanding. This term really means this completely other thing. What matters is the meeting of the minds, right? What matters is what you really mutually understood, right? Contracts are all about meetings of the mind. And damn it, what your mutual understanding was chickens. You wrote two by fours, but what you meant was chickens. Deliver the goddamn chickens. These are some of the fun things that we've had when it comes to contracts. And it's like specificity. And again, it bears repeating. All these problems can be solved by just specifying it in the contract. Look, dude, if you want chickens, just write fucking chickens. Just if you want delivery at 7 a.m., just say 7 a.m. If you want residential concrete, just write residential concrete. If you want the food grade chickens for human beings, just write that in the goddamn contract. Just put it in the fucking contract, please, for the love of God. And if you do that, you'll solve all these problems.